Hello, everyone, and thank you for joining us this morning. My name is Jumana Qadour, and I'm the head of the Syria portfolio here at the Atlantic Council. And thank you for joining us for today's event, Pursuing War Crimes, the Meaning of Justice in the Syrian Context. This week, we mark 10 years since the beginning of the Syrian uprising. Before I begin today's program, that we are thankful to be co-hosting with the Simon Scott Center for the Prevention of Genocide at the Holocaust Museum. I want to take a moment of silence for at least 500,000 Syrian lives lost over the last decade and the tens of millions of Syrians across the world and in Syria who continue to suffer. Thank you. I also want to make a few general announcements before we begin. Please note that this event is public and, of course, on the record, and we invite you to follow the Atlantic Council Syria work by checking our website or following us on Twitter at ACMidEast. You can also follow the Simon Scott Center at CPG_USHMM. Make sure, as usual, to please submit your questions through the Q&A function, and do please include your names and affiliations. We have three distinguished speakers with us today to talk about what I think is one of the only beacons of light in the Syria file. In late February of this year, we saw courts in Koblenz, Germany, issue a guilty verdict for Iyad al-Gharib, a member of Syria's intelligence directorate, for state-sponsored torture, and he was sentenced to 4.5 years in prison for his torture of over 30 Syrian citizens. A witness that testified in court, Wissam Miqdad, said that giving testimony felt like the first time that he told his story, that he felt it could actually make a difference. There are currently complaints and lawsuits filed across the world, including in France, Germany, Spain, and the Netherlands. And we are gathered here today to hear more about these cases and what impact accountability is having on Syrians. Without further ado, let me please introduce our speakers who will be discussing with us this timely topic. So we'll first begin by hearing from Ambassador Stephen Rapp, who is currently a senior fellow at the United States Holocaust Memorial Museum Center for Prevention of Genocide, and at Oxford University Center for Law, Ethics, and Armed Conflict. From 2009 to 2015, Ambassador Rapp was the ambassador at large, heading the Office of Global Criminal Justice in the US State Department. In that position, he coordinated US government support to international criminal tribunals, including the International Criminal Court, as well as to hybrid and national courts responsible for prosecuting persons charged with genocide, war crimes, and crimes against humanity. Ambassador Rapp was also the prosecutor of the Special Court for Sierra Leone from 2007 to 2009, where he led the prosecution of former Liberian President Charles Taylor. And from 2001 to 2007, he served as senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda, where he headed the trial team that achieved the first convictions in the history of leaders of the mass media for the crime of direct and public incitement to commit genocide. We're very happy to have you, Ambassador. Next, we're going to turn to Dr. Thank you. Next, we're going to turn to Dr. Yasmin Nahlawi, who is a legal consultant with a research focus on the responsibility to protect doctrine and the Syrian conflict. She leads a project to investigate the commission of international crimes in the 2012 Daraya massacre, in addition to guest lecturing and delivering international law training to Syrian NGOs. Her recent book is called The Responsibility to Protect in Libya and Syria, Mass Atrocities, Human Protection, and International Law. And she holds a PhD in international law from Newcastle University. And finally, we'll be turning to Sarita Ashraf, a barrister specialized in international criminal law and senior advisor to the US Holocaust Memorial Museum Simon Scott Center for the Prevention of Genocide. In 2007, Sarita was part of the startup team of the International Impartial and Independent Mechanism for Syria, otherwise known as the IIIM. From 2012 to November 2016, she served as the chief legal analyst on the UN Commission of Inquiry on Syria. She's a visiting fellow at the Blatnovic School of Government at the University of Oxford and co-editor of the book, The Syrian War Between Justice and Political Reality for Cambridge University Press. We'll definitely have closing remarks by Naomi Kukoler, who serves as the director of the US Holocaust Memorial Museum's Simon Scott Center for the Prevention of Genocide. And finally, with that, I'd like to begin our conversation today. And I first would like to start off by asking Ambassador Rapp some initial questions. I'd also like to note that Ambassador Rapp had some recent relevant publications that our team here at the Atlantic Council is going to share in the chat function for our audience to read after the presentation. So Ambassador Rapp, let me start off. First of all, it's a pleasure to have you and to be able to host you here. And I had a couple of, I think, questions for you on behalf of our audience. So could you please start off by giving us an overview of violations in the Syrian conflict? What are the most important accountability efforts taking place today? And what do you think really sets Syria apart from other contexts that you've worked on? And with that, what also makes it one of the most difficult, what makes it more difficult than other contexts that you might have addressed in the past?
Well, as you indicated earlier, at least 500,000 of our fellow human beings have been killed in Syria during the last 10 years. Keep in mind that number was reached by the UN about 5 years ago, and then they stopped counting. Our friends in the Syrian Observatory for Human Rights put the number over 600,000. But many of these, the vast majority of the individuals that have been killed aren't combatants in armed groups. This has not been a war that's been fought like World War I across a Western Eastern front where soldiers have suffered and died. It's been a war in which the civilians have been targeted and victimized in massive ways, making Syria the worst atrocity, the worst ongoing atrocity of this 21st century. The crimes include this state machinery of disappearance, detention, torture, and murder, in which roughly 200,000 people have been disappeared into these horrific detention centers run by various state security services, most prominently military intelligence, where they are profoundly mistreated from the welcome party when they're beaten and ribs are broken during the course of just detention and their treatment there without even interrogation, starved, mistreated, beaten, and then during interrogation, suffering every kind of humiliating and degrading and brutal treatment, eyes being gouged out, organs cut out, the chemical burns, horrendous. And of course, for that, we have the evidence in the Caesar photos during a period of time when a military police photographer was tasked, his team, to photograph corpses that were coming out of detention facilities in Syrian detention facilities in Damascus alone. And those numbers total around 11,000 individuals, among whom we have 6,700 distinct individuals shown as corpses with evidence of what killed them, 4 or 5 photos of each. And we, of course, have as well massive documentation of what the regime was doing when it faced an uprising, when people were in the streets hoping for freedom and democracy and chanting peaceful, peaceful, peaceful. The response wasn't peaceful. They and so many others, some not involved in demonstrations, were put into this machinery of death, and at least 128,000 today, individuals we can actually name. We have no idea what happened to those individuals. Sadly, tens or thousands are probably dead. That's the most extreme crime that we have proof of. But of course, we also have the use of chemical weapons, a crime that we thought we turned the back on after World War I, largely a norm that's been observed internationally since then. We've had attacks on hospitals and doctors and humanitarian actors, one of the oldest norms in international law dating from the Geneva Convention of 1864. So all of the rules that protect civilians in armed conflict or in any other situation in which there's disputes have been violated, and frankly with impunity. And basically the kind of things that we were able to do in Yugoslavia, in Rwanda, in Sierra Leone, and elsewhere, it's been clearly signaled to this regime, because of the protection that it has from Russia, that they can get away with those crimes. And obviously we've seen the veto of Security Council resolutions to send it to the ICC, the veto of global sanctions, the veto of really any kind of criticism. So that has been the hardest part of this for those of us that have put our heart and soul into trying to establish accountability in the hope that we can protect people by sending the message that if you commit these crimes, there'll be consequences under the law. So We are, however, and we can talk about it a little more later, turning the corner in terms of what's been possible to do in domestic systems in third countries, particularly as you mentioned, with this first judgment in Germany against a low-level sergeant who was involved in rounding up 30 people and knowing they were going to be moved into this detention facility, et cetera. So his sentence was relatively small, appropriately, and he came out in 2012. His co-defendant, who's still on trial, there'll be a judgment in that case later this year, facing 58 counts of murder, 4,000 counts of torture, and a possible sentence of life. There are other places in which justice may be possible. So even while the conflict is ongoing, even while these crimes continue, even while 128,000 people are missing and nobody knows for sure what happened to them and their families, imagine every day the horrors that they may have suffered in the past or may be suffering as we speak, that there will be some justice in the future is something that we got to continue to press for and send a clear signal that no matter what happens in negotiations, that justice can't be dealt off the table and that these kind of crimes can't be committed with impunity. Or Syria and the victims, horrendous things have happened. Same things can happen elsewhere wherever dictators want to retain power and their people don't want to see that kind of tyranny continue.
Thank you. Thank you, Ambassador. Could you, I mean, I know we've briefly mentioned other efforts, other legal efforts taking place, but could you sum up for us what are the most important of those? What are you watching closely to see unfold throughout the courts in Europe?
Well, let me mention, of course, that we've got this idea that if a perpetrator is present in your country or one of your citizens or a dual national has been a victim, third states can prosecute. Usually those kind of cases haven't been pursued until sometimes many decades after the crimes. We have cases still from Rwanda. We still have cases from Nazi Germany against 95-year-old defendants. But it often takes a very long time. So it is happening as we speak in certain countries, and that's a reflection of the massive documentation that's been developed. Sarita, whom we'll hear from earlier, was a leading staffer of the Commission of Inquiry established by the UN Human Rights Council, where there's no veto and where it's been possible to have that commission operating now for almost the full 10 years of the conflict, writing reports every 6 months. We've also had initiatives to work with civil society and develop really very good methods of bringing evidence out. And that's led to groups like CIJA, which I chair, which has almost 1 million pages of documents. Others like Fadel Abdelghani's Syrian Network for Human Rights that can tell you precisely when victims disappeared, when certain attacks occurred, et cetera, that has mapped the entire conflict of Syria. Media archive with more than 2 million individual videos that can identify when, where, and how, and show that it wasn't a fake. There's been fantastic work done in that area. And then we have this mechanism that was established by the UN General Assembly by a vote of 105 to 15 with Russian objection, which is consolidating all this material and making sure that it's not biased because the private or the NGO material might be biased by who was taking it. And so that's been a very positive thing. So that's why I say we have such profoundly powerful evidence here, in ways more powerful than even we had at Nuremberg. Nuremberg, we had wonderful, proof of horrible crimes from the Nazis' records and papers, but they never took pictures of individual victims with identifying information on each victims and additional identification of when and where they were killed. That's something we have in this situation. So that's all been positive, and that's assisting European prosecutors that have jurisdiction to do these cases. So there are at least 13 other cases that are moving in various European jurisdictions, some involving now chemical weapons. We hope soon involving attacks on hospitals, where we can either prosecute someone who's there in person in that country or nearby and can be extradited, or we can charge some high-level actor, as France and Germany have already with Jamil Hassan, head of Air Force Intelligence. Of course, he's not in Germany or France, but for the rest of his life, he won't be able to go anywhere without the danger he's going to be extradited. So there'll be other charges like that. So those are the things that are happening. I mean, later we can talk about ideas to take this up a notch. But there's no question that in Syria, we're finally seeing this universal jurisdiction third country case was working, but it's been because of all the documentation in which Syrians have taken a role. If it were just the police in Germany that were having to try to figure this out, it would be very, very difficult and and we wouldn't have had it even now, which of course is much too late for so many victims, but at least that's not a major step in international justice.
Yeah. No, thank you, Ambassador. I'm going to come back to you. We definitely have a couple of questions that I think I'd like to ask on behalf of the audience, but let me now turn to Yasmin. Dr. Yasmin, you've been involved in Syrian local efforts to spearhead accountability mechanisms. Can you tell us a bit more about the Syrian perception of all of these accountability initiatives? What are Syrian reactions to the recent Koblenz trials, for example?
Yeah, thanks, Jumana. Syrians overwhelmingly welcome these various accountability initiatives and are very supportive of them. And this is irrespective of the background of the accused or of the specific faction that they were aligned with. But it's also really important to point out that to Syrians, this doesn't represent justice. This is a precursor to justice. And the reason that I say this is that the remit of the ongoing accountability initiatives are very limited. So we're confined to individuals who've made their way to countries that are willing to exercise universal jurisdiction. So we're not necessarily prosecuting the highest ranking. We're not necessarily prosecuting those bearing the greatest degree of responsibility. We're not necessarily choosing cases based on their significance for Syrians or for long-term justice. We're simply using the legal avenues that we have to prosecute who we can. Who is available? What evidence do we have? Which evidence is the most close or tightly knit? So this is an important point to mention. Another thing, though, in terms of what the cases have exposed or uncovered, are certain topics that the Syrian community has to grapple with moving forward. So if we think of these trials as a precursor to a future and wider transitional justice mechanism that hopefully will be Syrian-led, then some of these topics that are emerging allow us to discuss them and to be better prepared for such a future transitional justice initiative. And I'll give an example from the Koblenz case is the issue of defectors. So both Anwar Ruslan and Iyad Gharib, who are the two accused, technically defected from the regime in 2012. Now, Anwar Ruslan is much more higher ranking. He was the head of investigations at the Khatib trial. He willingly served the regime for 23 years. But nevertheless, both of them technically defected. And what was also interesting was that some of the witnesses in the court were also defectors. So it begs the case of how do we want to deal with the issue moving forward? Now, the Koblenz case is a German court and it dealt with the issues in accordance with German national law. But nevertheless, it's important and quite interesting to be able to deal and discuss with these issues as a Syrian community so that we can be better prepared for future transitional justice initiatives.
Thank you, Dr. Yasmin. Let me ask you a follow-up question to that. So, what are the major challenges, since you're also working with a lot of the Syrian organizations that Ambassador Raab talked about to try to, to piece together a lot of the evidence and to bring forth witnesses? What are the challenges faced by Syrians and Syrian organizations in particular that prevent them from moving quicker or more efficiently?
So as you can imagine, there are immense challenges to Syrians and Syrian organizations in just turning the wheel of accountability. And one of the biggest ones I've mentioned is the limitation of who can we prosecute, what avenues are available to us at this time. Other challenges include working with war crimes units in various jurisdictions that are themselves very overstretched and simply don't have the capacity to deal with the scale of cases that can emanate just with respect to Syria within their countries. And also bearing in mind that these war crimes units don't specifically operate for Syria or for Syrians. They have a universal scope in which they work. Another challenge pertains to witness protection. And this has two prisms. So the first part of protecting witnesses is to secure the person and the anonymity, if requested, of witnesses in bringing them in and delivering them to the court. So some witnesses may be within the countries in which the cases are occurring, but other witnesses may have to be flown in, for example, from Turkey. So securing the person and the anonymity is one challenge. And another challenge is more long-term, securing their person and their families in the longer term. And we actually saw this issue play out in the Koblenz case when it was discovered that the families of one of the witnesses was threatened and harassed by the family of one of the accused. So it's a very real and tangible threat. And the last challenge I'll mention, and this is a really important one, is working with national courts to make sure that these cases, while they are domestic in scope, that they also reflect and take into account the very real impact that they have on the Syrian community. So, for example, yes, the Koblenz case is a German case. It operates in accordance with German law. It is being conducted in the German language. However, we can't deny that the Syrian people represent the primary party to these proceedings. So, for example, the court in Koblenz refused to record the trial. And this means that lawyers, Syrian lawyers, 10, 20, 30 years down the road will never have a written transcript of the Koblenz trial. And they also denied the right to simultaneous Arabic translation for people that were attending these trials, and many of whom were victims, family members of victims who were attending the court sessions, even though they couldn't understand what was being spoken. And a motion to petition the court to allow for simultaneous Arabic translation, unfortunately, failed.
Yasmin, I have to ask, why was that the case? Why were they prevented from translating it and recording the trial?
So this is typical procedure for German cases, and again, this is the issue of, yes, it is a German case, but we want to work with these cases on the basis that they transcend Germany in a way. And the court cited security or confidentiality as one of the means of, or as one of the premises for rejecting simultaneous Arabic translation. It said that then the court proceedings could be leaked. And it's also important to mention, though, that simultaneous Arabic translation is already being provided in the courtroom in Koblenz because the accused are Arabic speaking. So there is translation already being conducted there. In September, the court finally relented and allowed for a simultaneous translation to be given to accredited journalists. But the sad reality at the time was that even though there were journalists that were attending the court sessions, they weren't accredited. So it wasn't until September, so 5 months after the case actually started, that the first Arabic-speaking journalist was able to access simultaneous translation into Arabic.
Okay, thank you. Thank you. I think that was an important clarification for the audience. Sarita, let me now turn to you. So you've been involved in a number of prosecutions and legal initiatives on the Syria file and beyond, and you focus particularly on the cross-section of gender and the law. Can you talk to us about why this intersectionality and why it's important in your work?
Yes, thanks, Jemana. I think it's very important as a base understanding to recognize that justice is not by itself automatically neutral. It contains within it often overlapping and interdependent systems of discrimination, and that can be in relation to being female, in relation to sexual orientation, in relation to class, and so on. So the simpler way to phrase it and to understand it in some ways when we're speaking about justice about Syria is in the conversations in the courtroom, in the media, in the conversations that surround justice and accountability. You know, who are we seeing? Who is visible? What crimes are visible? And are we having an inclusive understanding of what justice we're achieving, who we're achieving it for, and how we're defining it? Often when we don't bring that sort of gender competency, that intersectional approach, you end up with a justice which is by default largely adult male centric, that disproportionately focuses on crimes which are more likely to affect adult male victims. One of the other questions is that when we're looking at a broader notion of justice, is our understanding of the harms that different groups are suffering, people with overlapping marginalized identities of suffering, are we reductive? Are we seeing the harms against them being presented in discussions about justice, in the narrative that unfolds through witnesses and indictments in a way that is unidimensional? And by that I mean, the most obvious example of that is when we speak about crimes against women and gender-based violence, specifically in relation to crimes against women. Are we reducing that to only sexual violence? Is the female experience of harm more likely to revolve around sexual violence, and then that person be seen as potentially a witness to other forms of violence rather than necessarily a direct victim of those other forms of violence? Very similarly, for children, there has been a tendency to view the prism of children's experience through the experience of being, for example, recruited into armed groups and used in armed groups. It's also not only about ensuring that we have an understanding of how harms are committed against, the full gamut of the Syrian population, but also to show we're not reducing their experience, the experience of marginalized groups to what we are, to the kind of victims that are most visible in media and most visible in terms of the advocacy. The pull towards recognizing international crimes when it's committed through acts that disproportionately affect male victims directly draws from the greater seriousness with which we view, investigate, and litigate crimes that happen to affect men more than women. That results in a range of structural and attitudinal barriers in terms of who is hired to do this work, which groups receive money to conduct this documentation, and so on, and who is invited to sort of speak about the documentation, whose voices are heard loudest and taken most seriously. The consequence of that is that we then risk that the rights of female victims and other victims from marginalized groups within the Syrian community risk being infringed. Their right to be free of all forms of discrimination, their right to equal protection before the law. These are all things that we risk infringing where we don't pursue an intersectional approach. As there's been a kind of some discussion around the Koblenz case in this discussion already, I did want to draw attention to a step forward that came about yesterday in the Koblenz trial in Germany. Yesterday, the Koblenz Higher Regional Court updated the charges against the main defendant, Anwar R., in what's called the Branch 251 or Al-Khatib trial. Initially, incidents of sexual violence in the Al-Khatib detention center had been posited in the indictment as charged as individual cases under German law, whereas torture and murder had been charged as crimes against humanity. It was an odd indictment decision. I could never really understand why sexual violence had been taken off the table as a crime against humanity. There had been a tremendous effort on the point from Syrian female activists, international kind of feminist activists, including people like Jumana Saif, Lily Kauther, to push forward on submissions that sexual violence should be included as a crime against humanity. And yesterday, the court agreed with them. And so those charges are now indicted as crimes against humanity, committed as part of a widespread and systematic attack against the civilian population. But again, this is not something that happened automatically or naturally. It came about through the pushing and consistent efforts of what is largely a female and feminist activist and legal community.
Thank you, Sarita. No, I saw that yesterday, and I absolutely agree with you that I think it was a very important step forward, especially in those trials, because we are bound to see more and more evidence of sexual violence having been used, especially in a lot of the torture cases. I wanted to ask you one quick question. So in our personal conversations, you emphasized the need to focus on treatment as opposed to the conduct of hostility violations. Can you expand on this a little more?
So conduct rather than treatment.
Yes.
Yes. So I'm not necessarily saying that.
Yes, sorry, I meant to reverse those.
Yeah. I'm not necessarily saying that there needs to be a prioritization of conduct hostilities over treatment violations. And here, perhaps I can explain a little bit for the audience that that when we speak about treatment of civilians and fighters who are no longer participating in hostilities, we're speaking about a range of violations such as murder, sexual violence, torture, enforced disappearance. So really how they're treated in the course of the conflict. When we're speaking at conduct of hostilities, violations, we're speaking really about how the conflict is fought, the use of chemical weapons, the use of indiscriminate attacks, uses of attacks on specifically protected objects such as hospitals, religious and cultural sites, and so on. Understandably, across not only in Syria but across the whole of international kind of accountability, there has been a pull towards addressing treatment violations, and part of and the simple reason for that is that it tends to be evidential. They're less difficult to gather information on. We'll see in the case of Syria, in the case I'm sure of other countries, that you do see a number of a focus on detention center related abuses. That's often because you have a static population held in an area for a period of time where they're able to, if they, survivors are able to speak about what they suffered, what they saw other people suffered, and how the hierarchy inside the detention worked, depending on how long they were there for. You can also then quite easily track through to people who can corroborate that, who were held with them, or potentially even people who defected from that facility who worked there. For controversial facilities violations, it is much more challenging. There's a tremendous effort underway at the moment to focus on looking at attacks on hospitals. One of the reasons that I emphasize of trying to spend more time and more resources to the more difficult task of documenting and bringing cases in relation to conduct of hostilities violations is that they have been a major aspect of the Syrian conflict. Historically, they are not indicted and charged because they're often it's very difficult to do so, to document what happened, but also to document the links. And so there is this era of this feeling of a culture of impunity that settles around these particular violations. One journalist, I think a couple who reports on Syria a few weeks ago said, you could look at Sri Lanka and answer many of the questions about conduct of hostilities violations based on what happened in Sri Lanka when it comes to the attacks on hospitals. So it is important that we install our understanding of these violations in the record of justice, that there is justice for victims of conduct of hostilities violations, but also that we uproot this culture of impunity that inevitably flourishes around where there's an absence of justice.
Thank you, Sarita. Ambassador Rupp, I want to just come back to you and ask you, I think, a very important question for those of us who've been following your work. I heard you talk about this in your recent 60 Minutes interview, but the efforts, as you said, even during this panel, have mostly gone after small and medium fish so far in the Syrian space, just given so many of the requirements needed to actually prosecute an individual in a lot of these European tribunals. But is there a realistic possibility that we will ever get to see Bashar al-Assad prosecuted for his role in detaining, killing, and displacing millions of Syrians?
Well, I think there is a chance, but let me just explain, why we're so challenged at the moment, and it's certainly the perspective that Sarita and Yasmin have brought. I mean, these European courts really aren't well placed and don't have the statutes necessarily or the capacity to do the high-level cases. Most of the European war crimes units exist in order to respond to cases that come to them from immigration service over people that have serious violations that are discovered they've lied on immigration papers. And those come to them, and those are sometimes low-level offenders, decades sometimes after when the conflict occurred, when the crimes occurred. And the idea of developing cases like we do at the international level, of going after the top individuals like we did Milosevic in Yugoslavia, or Charles Taylor in the case of the Special Court for Sierra Leone, or Prime Minister Kambanda in Yugoslavia, in Rwanda. That's not what's done, and you don't have the sort of effort to also do key thematic cases that deal with things like conduct of hostilities or certainly the poison gas issue is there, and there are a whole variety of different kinds of crimes in different regions in which things have occurred. And of course, we're not just talking about crimes by the regime, though I'm always wanted to let people know that 90% of the crimes committed in Syria have been by the regime. I mean, horrible crimes by ISIS, by Jabhat al-Nusra, sometimes by those armed groups, et cetera, and certainly by some of the international actors like Russia that's come in there. But we're talking about a regime that on a continuous basis have carried out crimes against humanity as a strategy, and they're doing it every day for the last 3,650 days. And so that's why that is so enormous, and it's all in with this state. And so those are the massive crimes, but those aren't usually the ones that European prosecutors are interested in. They're looking at the ISIS guy that came back that might be a security threat there, or they're looking at the low-level person that they identify. I think the answer is more coordination between them. The Germans have pure universal jurisdiction if their national prosecutor general says it's in German interest and they have a lot of witnesses in the country, et cetera. And they've made that determination on Syria. Other states have to have a more specific link, the presence of the perpetrator in the country, or that there's one of their own nationals as a victim. And that's restrained a lot of states from doing very much in this space. And then some states where you have high-level offenders don't have the capacity. We're dealing with a case in Austria where they have one prosecutor working on a very high-level case, has no support from judicial police. The victims groups have to bring the witnesses from all over to his office in order to build that case. And it should have been filed, frankly, years ago. Spain has we had a case of a victim's sister, a torture victim in the Caesar photos. And under international law for forced disappearance and torture, she's a victim. We started her case in Spain. It was approved by the judges, but then the government at the time said, no, we can't go forward. And they appealed and said, she's not a victim. She's not direct enough, even though international law is to the contrary. Well, they won in the Spanish courts. We're hoping to take that to the European Court of Justice. So you always have these kind of blockades that keep you from really doing the cases that you'd like to do. I think the answer, though it would be in some respect quite novel, would be for the states that are interested, and this need not just be European states, they could be other states, would be to pool their jurisdiction. Of course, the question then is who pays for the court? There'd be resources required, but we were in consultation with various Syrian groups who recently started looking at something perhaps more modest and more saleable that would be a referral court, where countries could refer cases to it if they couldn't do it themselves. So it wouldn't duplicate the good work of the German prosecutor. But when they've got some case that they don't have the capacity on, or where the state doesn't have the law that fully utilizes the jurisdiction that's allowed under international law, that court could take it on. They could also deal in a much better way with the witness protection issues, which are difficult for states to handle, and deal with this question of cross-border evidence and the ability to perhaps have a witness here testify who's an insider testify against a higher level perpetrator over there. So there are a lot of ways, and then you could do the thematic kind of cases. So at the moment, we're beginning discussions with various European countries to see if they would do this, particularly if it would be largely something with only a small core that could benefit from people sent from those systems. And then if it were approved by the General Assembly, which I think could be done, because we got the vote on the IIM by 105 to 15, it would represent an action by the international community as a whole. And it could then be in a situation where, unlike individual states which have to honor head of state immunity, it could be an international court that could prosecute Assad or others that might have diplomatic immunity or other sort of barriers to prosecution. And it could have a model statute. There could be a lot of things that could be done very positively in this area. So I'm sort of all in at the moment, trying to find countries, if we get a critical mass that can go forward on this idea. I think it's so essential for the future of not just Syria, and that's my heart bleeds for Syria today and every day. But these same crimes can be committed elsewhere, and if the signal is sent by this conflict, you can get away with it, and you can kill, murder, torture, gas your way to victory. You can survive and be normalized. Then I think none of us are safe in the future.
Thank you, Ambassador. Yasmin and Sarita, I have my own personal questions, but I see the audience submitting their questions, so I want to get to some of those because there's some, I think, some very important questions that are being asked. So the first we get, and I'm going to read out a few of them and let you guys, take which questions you'd prefer to ask. So from Stephen Andrews, we have a question actually directed to Yasmin. R2P has arguably failed in Libya, failed in Syria, and failing in Myanmar. Is R2P a relevant argument anymore for Syria? And if so, how? We had two questions, both from Peter Walsh as well as Stephen Andrews, that are asking both about, for example, the evidence surrounding collusion by the regime and other Salafist extremists. So is there work being done to hold the regime additionally accountable for work, for example, and crimes committed by ISIS and other terrorist groups? And other groups in general. So what other efforts are being made to address crimes of other groups? And then from Barbara Slavin to Ambassador Rapp, would it be helpful if the US joined the ICC? Let's start with those questions.
I will answer the question on R2P, since that is very much up my alley. In terms of this R2P relevant argument, my work on R2P, basically what I argue is that the responsibility to protect is not a legal norm. It has not been approved in any treaty. It has not been signed into law in any way. But the way I see it is that it simply brings together law that we already have under international law. It repackages it and it builds upon it to strengthen international legal norms for human protection. So, for example, we don't need R2P to say that a country can't commit crimes against humanity. We don't need R2P to say that you can't torture your people. Those laws already exist within international law. What we need to do is to enforce the laws that are already there. So international law, basically what I'm saying is that even without R2P, we have a wealth of international legal tools that we can employ with respect to the Syrian conflict. So for example, the General Assembly in December 2016 established the IIIM by a vote of 105 to 15, as Ambassador Rapp mentioned. Now, the General Assembly did this pursuant to its residual responsibility to maintain international peace and security. The primary responsibility for international peace and security lies with the Security Council, but the General Assembly within the United Nations Charter has a residual responsibility, and it has powers that it can act upon, and it used these powers to create the IIIM. And similarly, it can invoke these same powers to recommend other measures. So we don't have to stop at the creation of the IIIM. The General Assembly has the remit to recommend measures pertaining to other aspects of the Syrian conflict. The Genocide Convention, for example, includes an obligation to prevent genocide. The Geneva Conventions include an obligation to ensure respect for the conventions. So we have legal tools available. Now, the pressing gaps within international law that R2P has failed to address is what happens when the Security Council vetoes resolutions pertaining to mass atrocity situations. And I think the way we need to develop moving forward is either we curtail the veto through a formal or informal agreement, or we have to identify means of circumventing the Security Council when it's paralyzed in situations such as the case in Syria. The General Assembly showed us a way of doing so through its establishment of the IIIM, but we need to make this a more regular occurrence. There needs to be some sort of a culture shift in the United Nations, whereby the General Assembly steps up as soon as it becomes apparent that the Security Council is paralyzed.
Sorry about that, my mute button. Thank you, Yasmin. Do we want to turn over Sarita or Ambassador Rapp? Which one of you would like to go first?
Sarita, are you ready, or I'll charge in?
Go ahead.
Well, the question from Barbara was relating to the U.S. joining the ICC. I think that would certainly be a good idea. I think it's not likely now. Obviously, we have a controversy at the moment over the ICC's jurisdiction over U.S. forces in Afghanistan, specifically on detention and torture that's created issues with the previous administration, and an executive order that needs to be stricken by this administration. We would be much better off if we were in the ICC, if we were working to make it an effective institution, making sure that it was focusing on the most serious cases in the world. But that's not likely to happen. The US would take 2/3 of the Senate to do that. We can't even ratify the Convention on the Rights of the Child, and every other country in the world has. We can't ratify the Law of the Sea Convention, and it's all in our favor. And China's in, and they lost the case on the 9-dash line, and the US can't really say anything about about it because we're not in. And so we hurt ourselves in the United States by not being part of the court. But Syria wouldn't be there in any case because it won't join because of all the crimes it's committing, and Russia will protect it from jurisdiction that would come through a Security Council referral, as occurred in the case of Sudan and Libya, and it already has with the veto together with China cast in 2014. So that's not going to solve that problem, and that's why I think it would be important for the United States to join this sort of the court that I just described. We are doing extraterritorial cases in the United States. We don't have many from Syria. We've had a couple cases of Daesh persons that have been prosecuted in US courts. We have, however, had cases under torture against Charles Taylor Jr. in Miami. There's a case out of Gambia now in Colorado. So the US does something in this area and has a very good investigative team. But we're better if we would join with others and pool jurisdictions so that Americans could work in those cases where the jurisdiction came from another country, where the person is present, or where there's a victim that gives the court jurisdiction, and being a participant in that. And quite often, as we saw from Nuremberg and on forward with the ad hoc tribunals, even with the negotiations leading up to the ICC, it was very important that the United States be a participant, if not a leader, in that process for it to go forward. So that's what we really need to ask this administration to do. I would note that there is one international court where this matter is coming forward, but it's not a criminal court, and that's the International Court of Justice, thanks to our friends, the Dutch, who have filed a case or have announced that they're going to file a case unless it can be negotiated in advance, and those negotiations have failed. Syria is not responding, but it is on the Convention Against Torture. And Syria is a state party. They're obliged not only not to torture people, but when it's credibly alleged, to investigate and prosecute the perpetrators, which of course are the forces of the Syrian state, and they're not about to do that. So the Kingdom of the Netherlands will take the Syrian Arab Republic to the International Court of Justice. We'll seek preliminary measures, and I'm confident that eventually there'll be very strong decisions regarding the mass torture by the Syrian state. On the other hand, no one will be prosecuted, and it will stand very importantly in international law, but it doesn't put anybody in jail. But that will be something that occurs, and something that will benefit enormously from the great evidence that's been brought in by Syrian victims and survivors, working with the international community, both NGOs and also the UN Inquiry Commission and New Mechanism.
Thank you, Ambassador. Sarita?
Yes, I was just going to say what arises out of this is how innovative the approach to justice in Syria have had to be for the crimes committed in Syria. Part of that has just been, in my view, kind of a failure at the level of the Security Council to maintain international peace and international order through the failure to either refer Syria to the ICC or else to really seriously consider an ad hoc or hybrid tribunal. So what we've seen now is this incredible wave of innovation around justice in Syria as a result of these kind of blockages in what would be perhaps more natural paths to justice at an international level. Some of that has been just the national jurisdictions stepping up, deepening their importance to the international criminal justice experience, but it's also seen in the Syria IIIM, in the idea of the pooled jurisdiction court, but also in efforts such as Guernica 37 that has made in putting forward submissions that have led to the opening of a preliminary investigation against alAsad in the UK. So just to respond to Omar's question on that, for those who haven't been following, the wife of Bashar al-Assad as a British citizen, she's facing possible terrorism charges in response to a legal complaint alleging that her speeches and public appearances in support of the Syrian army implicate her in crimes, including in the use of chemical weapons. So some of that is related to potentially incitement or an aiding and abetting case. It's a very innovative approach. It speaks to the kind of complete thirst for justice in Syria. Of course, we do want to have a justice which is more encompassing, which reaches out to a larger number of Syrian victims who see their plight spoken to in the criminal proceedings. But I do think that it's certainly an innovative step forward. I think it restarts the conversation more seriously about justice for Syria in the national courts, and I think particularly justice for Syria in the UK courts, which has been lagging, in my view, behind countries such as Germany and Sweden.
Thank you, Sarita. Okay, we're getting a lot of really good questions, and I'm trying to make sure that we prioritize, I think, some of the most important ones. Let me ask real quick. There's a question from my colleague Gisunia, and she's asking, in terms of reducing incentives for bad actors to continue fueling the conflict and conflicts elsewhere, what can be done with respect to holding the financial actors in the conflict to account? There are many war profiteers. We have another question from Nicole Wittersheim, who asks, I know the crimes are horrendous in Syria, but in relation to the progress on justice, Syria is inspiring for other places like South Sudan, where no justice has moved forward. What specifically is transferable in the Syria instance for those seeking justice while the conflict continues? And then we have a couple of questions here that I believe were answered more or less, but about, I think Ambassador Rapp's comments about creating tribunals or efforts with, for example, within the General Assembly, not necessarily just through the ICC mechanism. So if you perhaps have any, closing thoughts on that, Ambassador, because we are getting some, and sort of how the lack of global unity on moving forward in Syria is impacting our inability to move forward on some of these justice mechanisms. I'll stop there.
Well, let me deal with the economic crimes issue first, and that's an extremely important one. There is a case in France, though it doesn't involve the Syrian regime, but involves ISIS and Lafarge, Holcim cement company that was paying money to ISIS to maintain its plant in northwest Syria, even while its employees didn't want to be there, and in a sense was aiding and abetting the crimes that ISIS was committing. That corporate case has been pursued in France, where there is a corporate liability for international crimes, and victims groups of ISIS, including the Yazidi victims, have come into that case. So that's a very positive step. The chemical weapons case that was filed just earlier this month by Mazen Darwish's group, Syrian Center for Media Freedom and Open Society and other victims, that case also is looking for corporate for companies that provided precursor chemicals, some of whom have been already prosecuted under trade law in Belgium, but there's other companies that have benefited this whole Syrian chemical weapons industry, et cetera, and getting behind that and reaching out even to companies not located in France, but who may be doing business is something that I think is promising and hopes to get, we very much hope to see real cases in court, even where we don't get defendants, human defendants, individual defendants in court. Now, just on this whole question of the General Assembly, as I indicated, there's been discussion for a long time, could the General Assembly go ahead when the Security Council doesn't and create a court on its own? And that idea has been mooted. On the other hand, the Legal Council of the UN, when the IIM was created and the Russians said it can't do this, their opinion was it's a mechanism, it's not a court. If the General Assembly created a court, that'd be too far. But it can establish this mechanism to investigate and further accountability. So we would have to overcome some precedents and some legal arguments there. I think the idea of the pool jurisdiction court, it's important to tie in the General Assembly, which every year, not just the year that we had the IIM established in '96, every year there's a very strong resolution, strong language, let's put it that way, on Syria that's adopted in December that comes out of the UN Human Rights Third Committee. And it almost always passes with 105 or so votes. And I think that in that, we should look for the strongest language on accountability. And particularly if we can go forward with this referral court, which doesn't involve, we hope, substantial expense, which will turn countries away, but will be something in which states consolidate and strengthen their efforts. if that were to be endorsed by the General Assembly, I think that would be very, very powerful. This has occurred before in the case of Cambodia. Security Council didn't endorse the court for Cambodia, the General Assembly did. So it's possible to use that as a tool once you've got the jurisdiction solidly based upon the country's jurisdiction. They're pooling it, the General Assembly is endorsing it. I think we'd have a very substantial legal basis to do this. The question is the political will of states prepared to do that.
Thank you, Ambassador Sarita.
Yes, I just wanted to quickly address Aisha's question around reparations, and to say that I think it's very important that we do speak about justice in Syria. That has largely been based on the idea of criminal accountability. But of course, it's important that we continue to expand that notion of justice. In June 2013, drafters of the Geneva Communique affirmed that there needs to be a comprehensive package for transitional justice, including compensation or rehabilitation for the victims of the present conflict, steps towards national reconciliation and forgiveness. However, there are, aside from just the pragmatics of how you would set up a reparations program in Syria, there's an even more challenging issue, which is reparations that they're most meaningful involve a recognition by the state that violations of fundamental human rights have taken place, of the state's commission of such violations and or its failure to prevent them, and of its commitment to rectify the violations and provide redress for harm. So it conveys to the victim that the state itself is committed to addressing the structural challenges of reparations and ensuring that they won't happen again. We're in a situation where, in this case, the state is responsible for the vast majority of the violations, the vast majority of the deaths, injuries, physical and psychological harm to the Syrian people, and it's not likely to align itself with the objectives or indeed the underlying philosophy of any meaningful reparations program. The Syrian government has never publicly acknowledged that it has made victims out of its own people, and as the government can't admit the grace of its own victims, it also cannot then agree or accept the formation of a collective memory that includes those victims. So it throws into question how the Syrian government could, for example, be involved in compensation of victims, engage in truth-telling, support memorialization initiatives, or create an appropriate environment for reconciliation when it continues to project a narrative of the conflict and its role that is untethered from reality and also impossible for millions of victims to accept. So I do think discussions of reparations are important. I do think pushing ahead of them are important. But we also have to think about what a reparations program would look like if it completely fails to involve the actor that is most responsible for the crimes that have been and violations that have been committed.
Thank you, Sarita. Yasmin, briefly, did you have any comment that you wanted to add about the question on South Sudan and what we can learn from Syria for the South Sudan case?
Sure, two brief comments on that. So the Syrian conflict and the accountability processes that have emerged as a result have spearheaded the emergence or the creation or the repackaging of law in two very major ways, but also in several other minor ways. But the major ones are the idea of universal jurisdiction, for example. This was more or less a theory before the Syrian case came out. There were sparse applications of universal jurisdiction before the Syrian conflict, but now the concept is being accepted as a valid way of trying individuals and as a valid way of conducting domestic criminal trials. And the second transferability that we see is through the establishment of the IIIM. This was unprecedented that the General Assembly would create an accountability mechanism. Although it's not a court, it was still unprecedented. And we've seen in the short time since 2016, the General Assembly has done this on two further occasions, in the case of Myanmar and in the case of ISIS. So already we see that the lessons that we've learned from Syria are being transferred over to other conflicts. And it goes back to what I was saying earlier about needing a culture shift within key institutions on how to deal with some of these pressing issues.
Thank you, Yasmin. So let me actually just ask you, I'd like all of you guys, if you'd like to make any closing remarks. But Yasmin, in specific for you, could your closing remarks include your thoughts on what these steps mean for Syrians now? So what are the Syrian people looking for from here? You know, what has this meant for them so far, and what are they expecting to see from us in the future? And then I'll allow Ambassador Rapp and Sarita to make your closing comment.
Thanks, Jumana. So again, these trials are significant, they're groundbreaking, but they're also the first step. And we need to pair them, in my view, with two more macro processes. The first is bringing an end to the crimes in Syria. So it's a bit bittersweet that we are achieving accountability in Koblenz and in other jurisdictions, but at the same time, while these trials are ongoing, countless other Syrians are being tortured and have crimes committed against them. So the first thing is to bring a wider end to the conflict. And the second thing that we need to pair these accountability initiatives with is a wider transitional justice mechanism. And I think Sarita alluded to this earlier in terms of reparations, truth-telling, memorialization, institutional reform, because accountability on its own isn't going to cut it, and we need a more comprehensive solution to facilitate a national healing process.
Thank you, Yasmin. And I think your important point you made earlier about this not being justice, but more accountability. I think that distinction is very important in how Syrians are viewing this. Sarita?
Sure. Just as a closing remark, we're obviously at the 10-year mark. There's a tremendous amount of suffering and really only cracks of light when it comes to criminal accountability, and very little in the way of broader criminal justice. One thought that I would leave those listening with is that there's no doubt of the level of harm. There's an awareness of the harm, but what the message we need to continue sending to governments, to institutions, is that if you want to have justice in Syria, there has to be serious efforts to ensure that it is funded, to ensure that the funding is there to keep these efforts moving forward, either for documentation, for looking to support for national jurisdictions, to support their war crimes offices, to ensure that they are resourced properly. And part of that is a conversation about who is getting that money. A lot of the conversations, the IIIM has been excellent on gender and intersectional approaches, but a great deal of the money flows into largely male-dominated institutions who also do great work, but are only a small portion of those only a small portion of the groups that need to be surfaced in the conversations around justice. So I know speaking about money is not the most interesting way to discuss it, but the truth is that there are a lot of calls on the public purse, particularly with COVID. But to achieve justice in Syria is going to require sustained and committed efforts to ensuring that there is the funding that can support a diverse range of groups and institutions that are working towards justice, including, for example, National War Crimes Unit and the Syria IIIM. Thank
you, Sarita. Ambassador Rapp?
Well, I think the broader message of what's happened in justice is basically that there will need to be truth and justice in Syria for there to be genuine peace. Periodically, you hear from negotiators who are conducting negotiations over constitutional change, and of course the government won't accept any surrender of the power of the Ba'ath Party and talks only about cosmetic things, refuses to admit the truth. Frankly, if there were peace on their terms, people would remain in custody, remain missing, and those that returned, if they were permitted to, would risk their life and limb being pulled right back into this machinery of torture and death. Periodically you hear Western countries say, wouldn't it be great if we could have a peace and reconciliation somehow, and we wouldn't have the refugee pressures and people could go home. And then we could, companies could go in and rebuild Syria. You can't rebuild a country on the property of people that have been tortured to death, the property that's been stolen from them. You can't expect people to go back and face the same crimes that killed their mothers, fathers, sisters, brothers, and sons. There needs to be a justice, and basically, whatever people talk about in these negotiations, these cases will go forward. And those that are implicated in these crimes, just like the 95-year-old German camp guards, will have to look over their shoulder for the rest of their lives. And of course, it's so much better that occur not hundreds or thousands of kilometers from Syria, but that it occur in Syria. I think that we really have to continue to send the message: no normalization, no reconstruction, continuation of sanctions, not against humanitarian objects, but against anything that's being used to maintain the power and the strength of this oppressive state, until such time as we've got a transition, and a transition that would include justice. It's a little hard, always, to negotiate something where people themselves would face trials, but you've got to have a pathway. that's developed by Syrians. And that can involve truth, it can involve reparations, it can involve prosecutions only of certain individuals and other ways to remediate and establish justice and truth with the others. But if you don't have that, there will be no peace, and there will be, frankly, no end to these crimes. And that, I think, is the message of what the Syrians have because of their work on the justice effort, on the evidence that they brought out, on the suffering of not just the 600,000 who've been killed, but the half the population that's been displaced and the other that live under tyranny today. That until we work on that problem and recognize that that's a key to it, we won't have peace. But I think today the realization, I think, has dawned on a great many countries, and I'm confident that particularly if we can take up the justice issue and start charging higher level individuals and send that message in a clearer way and make it absolutely positively a reality, that there's consequences. We need that if we're going to have genuine justice and genuine peace for Syria.
Thank you, Ambassador. Thank you for your comments, Dr. Yasmin, Sarita. It's been a pleasure to host you here at the Atlantic Council. I'm going to turn it over to Naomi Kukeler of the Holocaust Museum to end this conversation for us. Over to you, Naomi.
Thank you so much, Jemana, and thank you for the remarkable panelists for your incredible remarks and guidance. I think that it's important for us, just at the starting point as we conclude, to just acknowledge the incredible work that Syrian lawyers, human rights activists, and the Syrian people, especially those who will be testifying in future cases and will be working to create the truth commissions and restorative justice processes, are undertaking. The weight of these issues falls directly on their shoulders. We merely try to help support and advance. I think there's 4 key things, just to conclude, that have come out of this conversation that I think are worth underscoring. The first is that justice means different things to different people. And we have to acknowledge that and recognize that we often have conversations about accountability because we struggle to find the solutions to how to bring an end to the conflict. And that must be our #1 priority. One of the second is that we have to recognize also that justice and accountability efforts can help deter perpetrators. We have anecdotal evidence that information released from the Caesar file changed for a period of time the treatment of detainees. The more information that is released, the greater the pressure is on potential perpetrators. Perhaps there are still those who are seeking to defect, but it also helps to make the case as to why there can be, as Ambassador Rapp said, no normalization of relations. And for countries like Denmark, who in the last few days have announced that they are going to be returning Syrian refugees from the Damascus area, I asked them to look at their neighbor and to recognize that Germany is prosecuting crimes against humanity for torture, and that we know that many of those who may be forced to return will face a risk of detention, because that is how the Assad regime has been able to retain control, through threatening the potential for detention, not just in the last 10 years, but this has been a pattern of behavior that both presidents, the current and previous, have used. Victim participation has been, unfortunately, a problem since the very first Nuremberg Tribunal, the International Military Tribunal. One would have hoped that we had made great strides in ensuring that the voices of victims and survivors could be heard. Clearly, from our panelists today, we have a long way to go. It's the Syrian people who need to know what is happening in the courtrooms, who need to have the record and need to be protected so that they can actually continue to advance these incredibly difficult efforts decade after decade. Because as we know, as Ambassador Rapp said, in the past 2 months alone, Germany has prosecuted or brought charges against a 95-year-old, a 96-year-old, a 100-year-old gentleman. They were all involved in the Nazi perpetration of crimes. The survivors will not rest. And as Ambassador Rapp said, for the next 50 years, those who've committed these crimes will have to live with the reality that one day they will likely face charges, ideally in Syria, if not abroad. So I would end by saying that it is remarkable, the innovation. I'm in awe of the heroes, as I think everyone on this panel is within the Syrian community, but there are also very serious ethical questions that have arisen in the course over the past decade of trying to advance the pursuit of justice and accountability. And I hope that that continues to inform our conversations, that we are working to make sure that the very people for whom we are seeking to work with and help to advance justice and accountability are actually put at the forefront of these particular efforts. It's a real honor to be able to hear from you, Yasmin, from Sarita, from Ambassador Rapp, and Jumana, immense gratitude to you and the Atlantic Council for this incredibly important and timely conversation.
Thank you all.